Well, I think we're all now ready to resume. Mr. McGrath, I think when we adjourned, you were being asked by Lord Leggett about the Australian case of P.T. Bayan, which I don't think we have in our authorities, although we have the earlier cases of Cardile and Patrick.
You're right, my lord. We don't. I managed to get a copy during the adjournment, and there appeared to be one main paragraph which expressly refers to Lord Nichols's analysis in Mercedes-Benz based upon the need to protect prospective enforcement, and that's paragraph 49.
Yes. Well, if anyone wants to refer to it, perhaps the members of the court could be provided with a copy of it overnight.
My lord, I'll ask my team to identify it.
Thanks. It's if anyone wants to look it up in the meantime, it's on Bailey, and the reference is 2015 HCA 36. Yes, thank you, Mr. Graff.
My lords, talking about the gateways, reliance is a great deal of reliance in the various cases on intent or spirit as a means of circumventing the plain and natural meaning. And we say that references to intent and spirit would serve an odd purpose here if they were to result in the plain and natural meaning not being adopted, because typically one would refer to the spirit or intent of a statute or a section in order to resolve some ambiguity, uncertainty, perhaps two competing versions of understanding which need to be separated, and one looks at it there. But here we've got a plain and natural meaning of the words we say, and not something that's been rejected as falling within the plain and natural meaning in all of the tiers of the schema. So we say that if spirit or intent is to oust that plain and natural meaning, then it would, we say, have to be strong and compelling. And we don't accept that there is a strong and compelling intent or spirit argument. And indeed, one might rhetorically ask the question, why adopt wording whose plain and natural meaning gives rise to an understanding of the gateway, which is indeed contrary to its intent and spirit. But it appears that as far as Lord Mustall is concerned in Mercedes-Benz, recognising that he needed to understand the nature of the freezing order jurisdiction in order to resolve the question of spirit and intent, and recognising, as I pointed out, that the only arguments that were put forward were arguments that he rejected, he appears to place a great deal of weight upon the rejection of any suggestion that assets alone is a satisfactory basis for jurisdiction, and he does that at 11755F. And our response to that is that this appeal is not one based upon establishing the location of assets as a basis for the assertion of jurisdiction. As your lordships are well aware, these gateways are constructed, and as Lord Justice Lawton reminded us, constructed as a means of identifying connecting factors between the jurisdiction and events or causes of action which justify the jurisdiction being involved in the determination of the underlying dispute. And the connecting factor in the injunction gateway is the control of conduct impacting within the jurisdiction. It is not the location of assets. Assets themselves may be a reason why one needs to control the conduct, but it's when one looks at the wording, it's nothing to do with assets, but it's to do with control of conduct, refraining or to do something within the jurisdiction. And we say, therefore, it's not a jurisdiction that's based solely upon the existence of assets, because with it comes all those requirements that I outlined at the beginning of my submission before one would engage the right to an injunction here, in terms of enforceability, conflict of laws rules, if they're foreign judgments, the criteria for the freezing order, etc. All of that is fed into the entitlement to fall within the injunction gateway. But then what I would also be keen to stress is that insofar as assets would form a reason as to why the BVI would be involved in any particular scenario, that's nothing to shy away from, in that under the conflict of laws, the location of assets, the situs, is generally considered to be the most appropriate jurisdiction in which to control conduct relating to those assets. What is often considered to be inappropriate is an attempt to rely upon the mere location of assets as opening up Pandora's box to bringing all manner of claims against the defendant based simply on the fact that he or she or it has some assets within the jurisdiction. And as I've hopefully made clear, that's not our case. We don't accept that we fall within the Karen and McLaren case that my friends rely upon, which is at page 13009, because there was an attempt to rely on the presence of assets within England to ground jurisdiction to prevent the respondent from proceeding for its own relief before the foreign court, which in this case would be Scottish, relating to assets within Scotland. So it was an attempt to rely upon assets within England to ground jurisdiction to prevent the respondent from proceeding in Scotland in dealing with assets within Scotland. Our case is nothing of that sort, and therefore the Karen doesn't help, my friend. And we'd also say this, Muddles, that ultimately the practical consequence of what we ask for is that in a scenario such as this case, if one were to just allow time to pass on, and assuming we obtained our judgment in Hong Kong and brought it over to the BVI, there would be no question about the entitlement of the BVI and the appropriateness of the BVI to support its enforcement process by way of a freezing order in those circumstances. What's sought is, and we say entirely consistent with the purpose and rationale of the freezing order, bringing it forward in time and recognising that the need to protect that process might happen at an earlier time. Plainly, the earlier one seeks to bring it forward, the greater the burden of persuading the court that there's a real likelihood that such a judgment would ensue, and that it would involve the BVI. But that's a matter for the discretion of the court, and there's plenty of filters within the freezing order jurisdiction that can deal with that. So, turning, if I may, the spirit argument on its face, a positive case as to why, if I have to fall within the spirit as well as the plain natural meaning. Firstly, we would say it does fit within the plain natural meaning of the words, and that's a good indicator, therefore, that it should be included. Policy favours the end result we suggest. If one looks at the various examples of legislation, the rush out of the Susquehanna boat into the lifeboats is very obvious and clear, and the direction in which they're travelling is the same in all of those jurisdictions. I appreciate it's another question whether or not one does by way of common law development or legislation. Policy clearly favours where we are going. The freezing order jurisdiction is precisely the sort of injunction one would want to be able to deploy to relate to conduct that may take place within the BVI, affecting the efficacy of the enforcement process. And the sole basis for asserting jurisdiction over the defendant under this gateway is to prevent wrongful conduct in respect of BVI's own enforcement process. This goes back to my starting point to be careful about language and in aid of foreign proceedings. And we're not using, unlike what was happening in the Susquehanna, the connecting factors in the gateway as some backdoor route to asserting jurisdiction over a substantive claim. So, and then when we ask ourselves, is there a legal principle or policy which has been identified for limiting service out regime to the determination of substantive rights alone? And we say when one strips the argument of the reasoning of North London Railway and its connection with Rosler and Hilbury, we say no, there's bare assertion, but no actual reasoned argument why the assertion of jurisdiction over a defendant can only be justified by reference to pursuit of a substantive cause of action. One can understand that in the context, perhaps, of the traditional understanding of an ordinary interlocutory injunction. But when one approaches it from the existence of a standalone freezing order, and of course one only looks at this question, the territorial question, assuming that there is a power to give standalone freezing order injunction, we say that the connection with the underlying cause of action has gone away. The reason why BVI does it is because BVI is the best forum, most appropriately located forum to control the conduct of the individual or entity said to undermine the efficacy of its own enforcement process. Lords, I referred also to, before the lunch adjournment, to Rosler and Hilbury, but I made the point there, and I just emphasise it again here, that the real thrust of that case was all about the inappropriate nature of the English court asserting jurisdiction over the substantive claim in that case, and the attempt to use or abuse the introduction of an injunction in order to put it within the gateway and bring those other claims with it. And as I say, that's not what we're seeking to do. And your lordships have my point that whenever Rosler and Hilbury seems to be discussed in Susquehanna, whether at first instance Court of Appeal or House of Law, very quick on its heels is reliance and justification by reference to North London reasoning. Lord Diplock's Petitio Principi, which is at 12834 A to B, just simply doesn't arise on our appeal for the reasons I've explained earlier, that there is no attempt to bring an underlying cause of action within the gateway. Then one asks oneself, what is the, on Lord Diplock's analysis, what are the proper parameters of this injunction gateway? And with respect to Lord Diplock, this is what we say he struggles to set out in any cogent form. The attempt to do so is at 12834 between C and D. Three possibilities are put forward. One is that it may, it's tentatively put forward as his first proposition, it may include quia timid action cases. He wasn't certain, but when one comes to Mercedes-Benz, Lord Mustel is doubtful. But what he's not doubtful about is that it doesn't give rise to a pre-existing cause of action in the strict sense. So it's difficult to see how quia timid could fall within the injunction gateway if Lord Diplock's requirement of a pre-existing cause of action holds sway. The second point, which I wasn't going to spend any time on, was a rather narrow point, which has fallen away, that the threatened breach of contract claim, an injunction in respect of a threatened breach of contract claim against a Scottish resident no longer applies, but it would be a very contrived and narrow view of the injunction gateway if it's felt that it's to be interpreted in a particular way for that reason. And then the category, there may be equitable rights and duties that are entitled to be protected or enforced by the injunction, which don't fall within the contract and tort gateways. But unfortunately, we're not left with any clear understanding as to how broad this category is, or indeed how this category is intended to fit within the idea that the underlying cause of action must itself fall within a gateway and therefore be subject to jurisdiction. Because otherwise, if it falls out with any gateway as a cause of action, then we're into the argument of Rosler and Hilbury that one is using the injunction, the tail is wagging the dog, one is using the injunction to bring in the substantive claim. Whatever the position is on that, and it's left unclear, that passage we say and rely on as indicative of the struggles Lord Diplock has we're seeking to find an answer to what is the purpose of the injunction gateway if you require the underlying cause of action itself to be subject to its own gateway and English jurisdiction. There is an element of textual analysis by Lord Diplock in the Susquehanna. I'm not going to dwell on this. I've briefly mentioned some submissions in respect of use of the words affidavit and action, etc. But of course, insofar as the greater weight one gives to the textual analysis before Lord Diplock of the words used in 1976, the more one needs to be concerned about any movements and changes in that wording. And certainly the reference to an action in which an injunction is sought, which is the wording he was dealing with, is not the BVI CPR rule in the 7.3, which is a claim for an injunction. So it's not the same wording, so we say that it's difficult to see that the argument should be driven in any way by close textual analysis of wording that in the end has and inevitably would change. And interestingly enough, if I just put out, as we put out in our statement of case, that as the White Book, I believe, puts it, uses the language that certainly in England, we now, my Lord Briggs.
You were sometimes going to deal with the argument against, which is a textual argument, which is that all the gateways are about what you can or can't get leave for to put into a claim form, which is the CPR successor to a writ, rather than, as here, I think it's set against you an application notice.
My Lord, the position in the BVI is that it was made clear in the once Black Swan was accepted, it was made clear that the old approach of issuing a claim form and then immediately staying it in order to get into the logic was not a form of procedure that was to be continued. And
Mr. Grant, sorry to interrupt you, but I just wanted to pause while we waited to see if Lord Briggs would rejoin us. We lost Lord Briggs for about 30 seconds there, and I don't know if he heard your answer.
I thought I was addressing Lord Briggs.
I did, yes.
Yes, you disappeared from our screens, and there was a little warning.
Well, I don't know how that happened, but I'm still here.
Fine.
I'm still here, and I heard what Mr. McGrath said. Thank you.
My Lord, yes. And so the procedure for serving a remedy in aid of overseas proceedings, rather than BVI proceedings, was set up to be the application notice in CPR Part 816. But your Lordship would have seen that at the end of my statement of case, that we say that if your Lordships are with us on the underlying principles, that procedure is the servant of substance, and that if the wrong document has been used, then no prejudice flows from that, in that both parties have been fully and properly informed of all stages and been able to take part in the proceedings. That the document that was used was the one stipulated as in a mandatory form to be used for Black Swan. Is it a claim form as such? No, but it is the document that you're stipulated to use for a remedy for the purposes of Black Swan in aid of foreign proceedings. And there's also there's a case, my Lord, I don't know if I've got it straight here, but immediately following the Court of Appeal's decisions in this case, in which Mr. Justice Jack addressed the question in which two respondents were not joined to a claim form. And he says, well, post the Court of Appeal's decision in this case, in Convoy, it's not possible to serve out, but it's not possible to just use an application notice. You need to bring them within the claim form. And he said that it's a great panorama. Well, just for your reference, it's paragraphs 5 to 6, 14540, and he used the Court of Appeal's CPR powers to rectify a procedural error in CPR 26.9. And that rule, your lordships can find at 13605. So, my lord, if this case was all going to turn on, we say, have you used a claim form or not? Then we haven't used a formal claim form, but what we have used is the form that we believed was the appropriate form, the mandatory form for at least Black Swan. And interestingly, of course, my lord, there is in Lord Mustle an argument that one of the differences between a freezing order and the use of a claim form is that you claim something in a claim form, and in a freezing order you're asserting something. And so he's trying to draw a substantive difference between the two documents. Well, with respect, we don't agree with that in this sense that any freezing order that would be served would be only an ex parte order, and therefore does require that relief to be determined at an inter partes subsequent hearing. And indeed, under BVI law, it expires after 28 days. So you need, there is a call to the respondent to contest and challenge the order. So it's, and as regards to the fact that there's some relief that's granted ahead of that inter partes hearing, well, so is service out in a normal claim form. Any exercise of service out of the jurisdiction inevitably involves some form of ex parte order to serve out and then call them back in to the jurisdiction to answer for the allegations asserted. So, my lord, turning to Lord Nichols's analysis, and rather in a similar way to what we did for the power issue, but it's a shorter analysis from Lord Nichols, because most of the heavy lifting on this aspect has been done on his reasoning about the Susquehanna and the nature of the freezing order. But as regards to territorial jurisdiction issue, his first step one, is that he's not using, he points out, not using the injunction gateway as a way of asserting jurisdiction over the underlying substantive dispute. And therefore, Lord Justice Sargent's concerns in Rosler and Hilbury fall away. And I would say also the concerns expressed in the Susquehanna, because one must remember that in the Susquehanna, the two proposition put forward was injunction with underlying cause of action and standalone injunction. The first one was the more preferred if either was going to be accepted. But you couldn't have the first one if the underlying cause of action wasn't within the gateway. It wasn't, so that goes. And you couldn't then have the second one because of North London Railway meant you couldn't have a standalone interlocutory injunction. And if we've dealt with the North London reasoning, then the objection to the second one, falling in the gateway, falls away. Step two, the abuses that come with that argument about underlying causes of action simply don't arise when you're dealing with a standalone freezing order, and that's 11767B to C. Step three, that if, as we're proceeding on the assumption that if I get this far in the appeal, that the court has recognised the power to grant standalone relief, then that recognition undermines the opposition in the Susquehanna. And he puts that in at 11767D to E. I should say, my lord, that Lord Nichols doesn't delve into the analysis of the underlying reasoning in the Susquehanna in quite the way that I did, but the end result is the same. Step four, he says it's a sensible conclusion to reach because it's within the plain wording and limited by the ambit of the gateway. So you're not giving an unrestricted jurisdiction. You're not at this stage opening the door to a worldwide freezing order that can typically be given when one is dealing with the defendant being subject to the personal jurisdiction, because you have to at this stage fall within the gateway. Step 5 is his comment that if he didn't do it, it would be a deeply regrettable state of affairs. That's 11767G to H. Step 6 is he takes comfort from the approach in the Channel Tunnel, 11768A B. And in step 7, he rejects the idea that by adopting his approach, one's involved in judicial anarchy or engaged in a process that requires legislation. And that's B to D of 11768. And building on Lord Nichols's reasoning, I just wanted to show you the position in Jersey. Now, when I've done this at the courts below the board, one's eyes roll because it's immediately said against me, well, Jersey isn't subject to the same precedent, doctrine of precedent of the Privy Council. And we accept that. But what is interesting and informative is that Jersey, shorn of those shackles, plainly had to take into account the reasoning in the Susquehanna and Mercedes-Benz, but chose as a matter of logic and its own reasoning to depart from. And we do think at this level, it is an exercise worth looking at. If for no other reason, then it tells us how one can make life so much easier in this area by the various steps that they adopt. And it's in the case of Crone, which is at 11375 of the bundle.
I can't hear him. Completely lost.
Yes,
I can't hear either.
Mr. McGrath, I'm afraid if you can hear me,
Yes.
that's good. Now we lost you there for a moment. You were just taking us to the Crowburn case at 11375.
My lord, if I could pull you back up 2 pages earlier,
Yep.
so that you can see the rule at 7B, 11373. Now, at the stage of this case, Jersey had already had their black swan moment, if I can put it that way, in a case called a solver law. So they've already accepted the power to grant standalone relief. And so we have their gateway is an injunction is sought ordering the defendant to do or refrain from doing anything within the jurisdiction, etc. And then if we go down to 11375, I won't trouble you with all the citation from Lord Nichols in Mercedes-Benz. Maybe go a bit further. Your Lordship will see that actually there's quite a few pages of Mercedes-Benz. If we go down now to 11377, but so he's looked at the reasoning of Lord Nichols, and at G, it says Mr. Mitchell argued that it was not for the court to adopt this line of reasoning, and that it was for the Rules Committee or for the legislator to decide whether the territorial jurisdiction of the court should be extended in this way. And he said, we cannot accept that argument. We have to construe Rule 7B of the 94 rules, and we have to do so in accordance with the current state of the law. The Court of Appeal and Solver Law adopted the reasoning of Lord Nichols and held that this court had the power jurisdiction to issue a Moravian injunction in aid of proceedings overseas. The court decided, in effect, that a Moravian injunction in such circumstances was the substantive relief sought, as Lord Nichols stated in relation to the rules of the Supreme Court and the passage from his judgment cited above. This undermines the basis upon which the conclusion was reached in the Susquehanna that the relevant subparagraph was inapplicable to Moravian injunctions. We can see no logical reason for holding ourselves bound by the ruling in the Susquehanna on the question of territorial jurisdiction when its substructure has been so fatally weakened by the Court of Appeal in Solverhub. And then, my lords, I've not troubled your lordships with the various extracts about the policy factors which favour a jurisdiction such as Jersey or BVI having such a power, but your lordships will see there in the extract from Solverhub those arguments, including based upon principles of comity. And it does appear that the principles of comity seem to have taken on a different significance now than perhaps in front of Siskina, when the concern might have been trespassing on another court's jurisdiction, and the need to recognise that one shouldn't do that, to now the understanding that the failure to provide assistance within legal reason, obviously, and availability of the power, the failure to provide assistance would itself be potentially a breach of the duty of comity. And that's entirely consistent with how the international commercial world and the various courts have deemed it sensible that they should operate. They know when not to trespass into another court's jurisdiction in dealing with the underlying claims that are before that foreign court, but providing assistance for any enforcement of a judgment that flows from it can hardly be said to be anything other than assisting. And when one truly appreciates that they only get involved when it's their own enforcement process that would be involved, then it becomes all the more clear. And then 11379 B, they say one of the primary pillars of judicial policy is moral principle. The court exists to administer justice and to do what is right between litigants. Having developed a remedy which is available to prevent litigants in Jersey from evading justice by moving their assets beyond the reach of the law, it'd be a curious state of affairs if that remedy were denied to foreign litigants. The ability to move money rapidly from one jurisdiction to another through the international banking system requires the courts to develop remedies to prevent abuse of that facility. In former and more slow-moving times, the Royal Court developed the Ordre Provisoire and the Arrêt Entrement to prevent litigants from avoiding their obligations. Today, the Medieval injunction is one of the means deployed to achieve the same end. And E gives their reasoning. In our judgment, the words of 7b of the 94 rule should be given their natural meaning. We accordingly hold that the Royal Court has the power to order service of its process on the defendant outside Jersey when an injunction is sought, and the injunction orders the defendant to do or refrain from doing anything within the jurisdiction. That now is a well-established and entrenched aspect of Jersey law, and we recommend the simplicity of the approach adopted there, and also the same policy reasons which justify it apply in the BVI, as the Court of Appeal in UKOS has previously recognised. And we say, once one recognises the standalone jurisdiction for the freezing order, then for the reasons I've indicated, it ought to fall within the injunction gateway. My Lord, I was making a point before my Lord Reid mentioned that Lord Briggs had dropped off, if I can use that expression. The point I was going to make was a point that we make in our statement of case, that the White Book uses the language of relegated to describe the gateways now. They're relegated to a practice direction. And for my sins, when I had to look up how one then reviews and revises practice direction, something that I'll never get back in my life that time, it appears to involve two judges. And we set it out in our statement of case, but it's effectively the Lord Chancellor, and I'm looking at my Lord Voss for shaking head or nodding, the Lord Chancellor and the Master of the Rolls. Not any, and without in any way suggesting that's inappropriate. But when you're faced then with arguments of international treaties and sensitive relationships with foreign countries and everything else on these gateways, just look at the way we go about revising them now. And the reason why we can adopt that approach, it's not because we don't think this is a serious affair, of course it is. It's because we have foreign convenience. And we can now filter out, even if you technically tick the boxes, we can still filter out inappropriate cases based upon somewhere else being a more appropriate jurisdiction. And that's an important factor when one looks at how one should approach what falls within the gateway. Because previously, when the foreign convenience argument was not either accepted at all, we were behind Scottish law on this, or was in its infancy, there wasn't that filter. So it was crucial as to whether or not you fell within the wording. And because there was no other way of stopping it after that. Whereas now we have a very clear way of saying, yes, you tick all those boxes, but no, you don't get home. Well, can I now turn, if I may, to just talk about legislation, both the BVI and generally? Generally, my lord, it's been said against me, and it was said many times in the courts below, that look at all the other jurisdictions apart from Jersey. They've had to legislate, therefore that is the only way forward here. But they're all examples of jurisdictions where they've had to legislate because they've considered themselves bound by the Susquehanna and Mercedes-Benz reasoning. The one jurisdiction that felt able to reason out of that reasoning while still taking it into account is Jersey, and it didn't feel the need to legislate. So we simply make the point that the fact that there has been legislation is not indicative that you had to have legislation. If one simply looks at it as a speedy way of avoiding the consequences of the Susquehanna, rather than awaiting an opportunity such as affords the board now, today, which is the first opportunity since Mercedes-Benz and the first opportunity since the Susquehanna to squarely tackle the appropriateness of the criteria with the nature of the freezing order jurisdiction. So we say it doesn't. And when one looks at what legislation has been put in place in those various jurisdictions, it's all of a similar ilk, where, as I say, ultimately the heavy burden and workload is done on discretion on the part of the judge, however one describes it, whether it's inexpediency or justice and convenience as per the Cayman Islands. And of course, I just point out that the Cayman Islands is one of the jurisdictions that recognised the existence of standalone freezing orders at common law, and yet nevertheless still went ahead, like the BVI has done recently, and legislated for the ability to grant such relief. So there we have a jurisdiction that was allowed and recognised standalone freezing order relief, and yet nevertheless considered it was sensible to avoid uncertainty by having legislation following. And turning to the BVI recent legislation, Lord, and the suggestion that basically that the board should be very careful. Of course, the board is going to be careful and doesn't need to be told that in ensuring that nothing is said or done that causes difficulties, but there aren't any difficulties. I mean, it's helpful to know that when I'm telling you this is a good place to go, that the BVI has rushed on New Year's Eve to get there by way of standalone. It doesn't provide service out. The statute only looks at the power issue, so it's no answer to both sets of appeals. But what it does show is that there's no strong constitutional or legal principles or policies which would suggest that this was a place that you should not go. It wholly undermines Broad Ideas' bold assertion that the Black Swan jurisdiction, which is effectively what's just now being codified, is unprincipled, jurisdictionally unsound, contrary to company law, and contrary to any concept of procedural unfairness. That's the case that I've been told I must meet on Black Swan. But none of that has featured at all in preventing the BVI from making sure that it got its Black Swan back. And when one reads the Court of Appeal judgments, one can see that the court is concerned that, yes, it would be a good idea, but no, they felt bound that they weren't able to do so. So there is still a reason. And of course, the reason is that ultimately I'm asking you to reconsider the interpretation of the statutory power and the injunction gateway, an interpretation which has been reached at common law and has an impact which goes beyond the simple issues of service out of a freezing order in a case like ours. As my statement of case shows, when one looks at the impact of the Susquehanna reasoning more generally on freezing orders and the Eggleton case, or injunctions generally and website blocking injunctions, one can see that they're not addressed by the equivalent of Section 25, and they still remain to be answered. But at the heart of this appeal is both the power issue of common law and the territorial jurisdiction issue. And even though the BVI has answered the power issue in legislation, that doesn't provide you with an answer you can work with for the territorial jurisdiction. Why not? Because the power issue requires you to examine the nature of the freezing order, and it's only from an understanding of common law of what the freezing order is as an animal that one can then decide, as Lord Mustall expressly recognised, how one can then interpret whether it falls within the injunction gateway. And you don't reason from the legislation to the gateway. One reasons from the common law understanding of the freezing order, which makes it necessary to examine the Susquehanna in any event. And so we say that, and the suggestion that these appeals are now only about costs. Well, costs are not nothing, if I can put a double negative, in cases of this nature. But it's not. I mean, there's cost undertakings and damages. There's no suggestions that people will allow us to have this injunction now continued under the new regime. So one then has to fight again for that. But I mean, ultimately, we say the court made a wrong decision, and we're entitled to have that issue determined. Now, as regards the legislation itself, we disagree with the suggestion that there is any tension or inconsistency between what your lordships might do today and that legislation. Paragraph 24A(1) is to be found at 13524. And one can see there it says the High Court or a judge thereof may grant interim relief where proceedings have been or are about to be commenced in a foreign jurisdiction. Well, there's no inconsistency or tension between what I'm inviting the board to do at common law and Section 24A(1). Both would be discretionary, may grant. 24A would go wider because it's talking about interim relief, and that might be wider than a freezing order. And then if one, it doesn't, and it's not in any way dependent on what the position was at common law. So your hand is not tied by 24A(1), saying what the position is under legislation. 24A(2), if I might respectfully say, and adopt Lord Justice Millett's language in Credit Suisse and Quogre as regards Section 25, it's not happily drafted, but we know what it says and what it means. But I say it's not happily drafted because it says on an application for any interim relief under subsection 1, the High Court or judge thereof may refuse to grant such relief if in the opinion of the High Court or the judge thereof, A, it has no jurisdiction apart from this section in relation to the subject matter of the proceedings in the foreign jurisdiction. Now, just pausing there, that's not a statement of what the common law is now. It's a statement based upon the opinion of the High Court or the judge, which it's a little bit odd. But I'm not asking the board, and I've made it very clear, I'm not asking you to use the freezing order to assert jurisdiction over the subject matter of the proceedings in the foreign jurisdiction. The underlying cause of action remains where it is, and the freezing order is sought on a standalone basis in the BVI. So there is no tension there. And B, it's inexpedient in the circumstances for the court to grant such relief. And if one stands back and says, what does that mean? It means if the court has no jurisdiction over the subject matter in the foreign proceedings, if that makes it inexpedient to grant the relief, then you shouldn't grant the relief. But I'm not basing an argument on this court having any jurisdiction over the underlying proceedings abroad. That is a matter for, in fact, I'm saying that we don't have that jurisdiction. That's what I'm saying. So on a standalone freezing order, you would have no jurisdiction over the foreign proceedings, and then it's left to the judge to decide whether that makes it inexpedient in his discretion, which is now guided by the cases from Motorola and Credit Suisse onwards, which is very broad discretion as to whether or not it should grant the relief. And there's absolutely no basis to suggest that one would be exercising the relief any differently at common law than one would be under this section. So we don't say that there's any tension or inconsistency with 24A2 in any way. And we also don't accept a more general proposition that the mere fact that the BVI has now legislated 24A is somehow freezes this board's common law ability to rectify the position of common law. We don't accept that as a proposition. And as an admirable example of a judge that wasn't having any of that, can I point to Lord Mustel in Channel Tunnel? And it's at page 10238, where, well, again, I'm not going to take you to it, but he refuses to allow the fact that the UK had enacted 25.3 but hadn't yet brought it in place as somehow freezing his entitlement to grant an injunction under 37. And you also see him analysing the entitlement to bring the injunction, notwithstanding it doesn't fall within the 1950 Act for arbitration or the 1975 Act. And so one can see the approach there, the judge saying, yeah, I understand that there's been some legislation in this area, but there's nothing about the legislation that causes me to say I can't do my job. And the job here, with respect, is, if I'm right, of course you could say we don't have to do it because you're just wrong, fundamentally wrong, but if I'm right that a wrong turn has been taken on the interpretation of common law, then that wrong turn needs to be righted, if I can use that expression, and the existence of the BVI legislation does not bar that. And we cited then Professor Burrows in our statement of case at 9251, and more recently from his Hamlin lectures at 14247 to 8. The thrust of his argument in those lectures is that it's only in exceptional cases that the common law should be considered frozen by statute, where what might be done would cause a clash, or indeed maybe the legislator has made it perfectly clear that they're ousting the common law ability. And we say, my lords, that that's not present here.
And is that right? Is there not a risk that if we were now to say that the common law has been misunderstood for the last 40 years, we would be cutting across this this enactment.
Well, my lord, it's the same common law that was recognised in the Cayman Islands. You'd be going that far.
Well, that's not really an answer. I mean, you'll be aware of this sort of issue about the way in which legislation impacts upon the court's development of a common law has been considered, for example, in the Supreme Court quite often. And Lord Burrows has been very critical of judgments of ours in that area. But a case, for example, like prudential assurance, where we were being asked to develop a law relating to legal professional privilege. But if we did so, it was felt we would be cutting across an area where Parliament had legislated and effectively occupied the field. Well, here, obviously, we'll have to consider whether what you're asking us to do would undermine the legislation which has just been enacted.
Well, in my submission, it wouldn't, because the legislation on its face is clear. But the submissions that I've been making to you, in fact, if one looks at the relationship between common law and statute as going both ways, that both can, either side can learn off each other, while in circumstances where one is not barred by the statute. One can see that it says may in 24A1, may grant the relief. There is no guidance, there's no framework in this statute as to the exercise of that discretion, save for the very broad inexpedient in 2. But 1 is the primary piece of the legislation. Now, I've put forward a view based on Lord Nichols that the role of the freezing order is one that's tied to the protection of the enforcement process, not a controversial view in many ways. And therefore, when somebody seeks to make use of 24A1, which isn't subject to any statutory guidelines, the guidelines that your lordships may give, not in this case as to the nature of the freezing order, would assist in the court understanding whether or not it was suitable to deploy that kind of interim relief. Plainly, 24A goes beyond freezing orders, but there's nothing that you would say as to when such freezing orders would be in play that would be inconsistent with any of the wording of the statute. And inexpediency is, as we've seen from Credit Suisse, a very broad term that would take into account all the factors that we say your lordship would take into account if faced with an application to serve out at common law without reference to any underlying legislation. Clearly, my lords, you need to look and be comfortable that one isn't trespassing. But in my respectful submission, I say that you're not trespassing in rectifying what we say was an inappropriate form of interpretation of the freezing order from its very outset, which has then led to, as I say, the approach to the injunction gateway. My lord, just very briefly, because I know I'm finishing at 3. On the Chabra jurisdiction, we say in a nutshell, this is an attempt to bring back through the back door the power issue, in the sense that we only get obviously to this argument if you're with me on the power issue, and there, if you're with me, then you're with me on the basis that there isn't an underlying connection between the injunction and the rights in a cause of action that require the two to go hand in hand, and that what one is looking for is the protection of the enforcement that may flow, enforcement of a putative judgment that may flow from a cause of action, even if it is abroad, and that all applies here in a Chabra jurisdiction, so that when one is looking at broad idea as BVI entity, if broad idea holds assets against which a judgment against Dr. Cho may be enforced in the BVI, then we say it's entirely within that understanding of the power issue and the underlying rationale of the freezing order, that any judgment that we brought over from Hong Kong to the BVI to enforce in that way would be one that was in accordance with its rationale and understanding of its jurisdiction and its proper parameters. And we say that the argument that you need to have the underlying CAD before you before the BVI court in order to make good the NCAD is simply another way of saying reintroduce that connection that we say is abandoned if you accept our arguments on the power issue. We would also point out to the court, and I won't have time to go through it, but in VTB and Universal, this issue arose in the Cayman Islands Court of Appeal with Sir John Chadwick, and he definitely went through the various cases and made it quite clear that he rejected the idea that the chapter jurisdiction did depend upon the NCAD and CAD being subject to the same set of proceedings. And your lordships will get VTB and Universal at 13214. And I should also just point out a reference that relates to material, but it wasn't cited in our statement of case on this point. And that is Mr. G's book at paragraph 13/013, footnote 61, citing Cartier and for this same proposition at 14697. And we also say, my Lord of Court, as was accepted by the BVI Court of Appeal, that our case is on all fours with the Black Swan case, and that case, which accepted the power issue, rightly we say, has been endorsed by the Court of Appeal in BVI in UKOS. And although broad idea Court of Appeal sought to distinguish it on the grounds that there was no challenge to Black Swan as such in UKOS, we say a clear reading of UKOS shows, and in fact expressly says, that there was a challenge to Black Swan made there by Lord Wagner as one of the counsel, and that challenge failed, and the Court of Appeal expressly endorsed, as you've seen in the extract I gave at the very beginning from Mr. Justice Kowali, endorsed the Black Swan line of jurisdiction. Lord, in the final point I would make, because I can see it through, is that on risk of dissipation, we would simply say that the Court of Appeal in the BVI did not have the benefit of the Hong Kong Court of Appeal judgment overturning the first instance refusal of injunction on the grounds of absence of risk of dissipation. And the Hong Kong judgment sets out very carefully at paragraphs 35 to 72 a view of the law which be very familiar to all concerned. It's page 2391, and it explains precisely why it is that there's plainly a risk of dissipation here, and we recommend that, your lordships, together with the fact that wasn't addressed at all by the Broad Area Court of Appeal, that Dr. Cho has not yet challenged in the BVI any aspect of the non-jurisdictional parts. He reserves the right to do so, but it hasn't challenged a good arguable case or risk of dissipation in the BVI. And of course, it's all about Dr. Cho's risk of dissipation impacting broad idea, and that simply is misunderstood or ignored entirely in the Court of Appeals case. Lord, I see it's 3 o'clock, and on that basis, I'll draw my submissions to a close unless any of your lordships have any comments or questions.
It appears not. Thank you very much indeed, Mr. McGrath.
Thank you very much.
We turn then to Mr. Morgan.
My Lords, I appear for Broad Idea International Limited, and if I may, I shall refer to the appellant as CCL. By this appeal, the appellant invites your Lordships to approve the existence of the so-called Black Swan jurisdiction, and thereby reimpose an order over all the assets up to a certain value and all the shares of Broad Idea, supposedly in support of proceedings in Hong Kong. Such a result cannot be correct in this case. And for those purposes, I respectfully adopt the analysis and reasoning of the Court of Appeal, and I also adopt the arguments in Broad Idea's written case. Subject to your Lordships, my oral submissions will therefore focus on 5 points. First, the order for which CCL contends cannot be characterised as being in support of the Hong Kong proceedings. It extends well beyond what CCL asked the Hong Kong court to grant against the sole alleged wrongdoer, Dr. Cho, and beyond any allegations made in those proceedings. Instead, it seeks to reach directly into Broad Idea's assets and interfere with the interests of its other shareholder, Mr. Choi, in the form of his shareholding. The second point is that Broad Idea, as a legal person, is entitled to the free use and enjoyment of its property unless there is some lawful basis upon which it is to be deprived of such. The lawful basis upon which a company can be deprived of the use and enjoyment of its assets, other than in satisfaction of its own liabilities, is limited, both as a matter of company law and as a matter of the test for injunctions against non-cause of action defendants. CCL has never made out an arguable case to be so entitled, whether in the BVI or elsewhere. Thirdly, the existence of a claim justiciable in the BVI asserting a right to have access to Broad Idea's assets is a threshold requirement for obtaining an injunction against Broad Idea as a matter both of law and the actual wording of the statutory power for the grant of an interlocutory injunction. That wording, that has been analysed and construed in England for almost 150 years, remains good. There is no good reason to depart from such well-established principles, particularly where the absence of the power for which CCL contends has now been addressed by amending legislation. The fourth point is that on any view, there is no evidence that Broad Idea's assets ever could be available to satisfy a judgment against Dr. Cho in Hong Kong Proceedings 399 of 2018. Lastly, the Black Swan case cannot stand as good law for the existence of a so-called Black Swan jurisdiction. It is wholly inconsistent with a company having separate corporate personality and the maintenance of proper limits on the scope of freezing injunctions over the assets of third parties. So if I may, I'd like to start with my first point, which is that the order for which CCL contends is not actually in support of the Hong Kong proceedings. Now, the order of the Hong Kong Court of Appeal appears at page 2372. And as you can see from that page, it's an order in the Hong Kong action in support of which CCL sought the assistance of the BVI court, namely HCA 399 of 2018. And the action is brought by CCL against Dr. Cho and 12 other defendants. This is the only action against Dr. Cho in support of which the Hong Kong court has apparently been asked to grant a freezing order. And you will note that neither Broad Idea nor Mr. Choi are parties to this claim. Indeed, there is no claim against Broad Idea anywhere in the world. Not Hong Kong, not the BVI, not Grand Cayman, where Town Health Medical Group Limited is incorporated. Nor has there ever been any application for a freezing order against Broad Idea's other shareholder, Mr. Choi, anywhere in the world. Over the page, at page 2373, you see from paragraph 1 that the order restrains Dr. Cho from dealing with or diminishing the value of his assets, and in particular his shares in Broad Idea. The injunction only relates to shares registered or held in the name of Dr. Cho and their value. It does not purport to restrain Broad Idea itself or the value of its assets. The injunction also does not purport to restrain Dr. Cho from causing Broad Idea to deal with its assets, nor does it purport to restrain Dr. Cho from causing Broad Idea to recognise any dealings in Broad Idea's share capital, other than if and insofar as it affects the value of Dr. Cho's interests in Broad Idea. I'm instructed that this order has been served on Broad Idea's directors in Hong Kong. The order therefore restrains Dr. Cho, as either a shareholder or a director of Broad Idea, from causing Broad Idea to deal with its assets so as to reduce the value of Dr. Cho's shareholding. That is the practical effect of this wording, as articulated in the judgment of Lord Justice Tomlinson in the English Court of Appeal decision of Lakatamia and Sue, at tab 71 of the authorities bundle, starting at page 11426, and at paragraph 23 on 11435, what he says is this: where, as here, the owner of a non-defendant company is subject to an injunction restraining any diminution in the value of this shareholding in that company, he is restrained from procuring that company to make a disposition likely to result in such a diminution. For practical purposes, as Sir Bernard Ricks points out, that is likely to mean that dispositions other than in the ordinary course of business are enjoined. That's not because the non-defendant companies are obliged to bring themselves within an exception to an order to which they are not subject. It's simply because transactions in the ordinary course of business of a company do not ordinarily result in a diminution in the value of shareholdings in that company. So as a matter of practical reality, Broad Idea, acting by its directors, all of whom are in Hong Kong, is already restrained to the fullest extent justifiable, namely that its directors cannot deliberately cause it to deal with its assets so that the value of Dr. Cho's interests in its shares is diminished. Accordingly, if Broad Idea deliberately does anything that reduces the value of Dr. Cho's shareholding in Broad Idea, then potentially its directors, already present in Hong Kong and served there, are at personal risk of being committed by the Hong Kong court. The Hong Kong court does not, however, purport to prevent Broad Idea from dealing with its own assets at all. It only restrains it, acting by its directors, from doing so in a way that diminishes the value of Dr. Cho's shareholding. The last point on this order, to which I would like to draw your Lordship's attention, is its duration, which is provided for on page 2374, namely that it continues up to and including the trial in the action HCA 399 of 2018. The order is therefore truly interlocutory to the disposal of the merits of the trial, at the trial. Might I now take your Lordships to the order of Justice Adderley at page 915, and this is the order which CCL seeks to have reimposed. The first point to note on page 915 is that whilst it has a claim number, there is no claim. All the applications made by CCL have relied upon this number, which relates back to the original ex parte notice of application, which you would find on page 8. There is no claim and no claim form. There is not now and never has been any originating process. Now, the applicant justifies this, and we'll learn from Mr. McGrath has told your lordships this morning or this afternoon, by reference to part 816B of the BVI CPR, and you find that at page 13,577. And you see there 6B, sorry, on the preceding page, you see this is under the claimant, how to start proceedings. And 6, subrule 6, is a person who seeks a remedy before proceedings have been started or in relation to proceedings which are taking place or will take place in another jurisdiction, must seek that remedy by application under Part 11. Now, that rule is in similar terms to the English CPR 25.41A, where a person seeks a remedy before proceedings have started in relation to proceedings that are taking place or will take place in another jurisdiction. They must seek that, make that application under Part 11. However, as the Chief Justice held below at paragraph 25 of her judgment in the Court of Appeal, which you find at page 981, there are no proceedings taking place or which will be taking place in respect of which Broad Idea is or will be a party in another jurisdiction. And the appellant therefore could not avail itself of this rule. There is a corollary to this point. Having obtained an interim order, a failure to commence a claim by the issue of a claim form is contrary to the rules. And that's CPR 17.2.5 at page 13594. If the court grants an interim remedy before a claim has been issued, it must require an undertaking from the claimant to issue and serve a claim form by a specified date. This follows the same requirement identified in England in the Practice Direction to Part 25A, paragraph 5.1, subparagraph 5A. Even if an applicant in this country, in England, is applying for interim relief under Section 25 of the Civil Jurisdiction and Judgments Act, the same rules apply. The Commercial Court Guide provides that paragraph F15.5 that a Part 8 claim form must be used before the relief is applied for, and a Part 8 claim form would be required if relief was granted in another division of the High Court. When Section 25 was expanded in 1998, the old rules of the Supreme Court provided at Order 25, Rule 8A, that one had to issue an originating summons to seek the relief. So the procedure has been the same, that the court has looked to some originating process to be issued. Now, CCL has in fact stated repeatedly that it was going to issue proceedings. It never gave an undertaking to do so, as it should have done, but it stated on a number of occasions that it was going to issue proceedings against Broad Idea imminently. And you see that, for instance, on page 33, This is a certificate of urgency dated the 27th of March 2019, and at paragraph 3 you see that proceedings will be commenced in the BVI against the respondents with the anticipated date of filing as the 2nd of April, by 2nd of April 2019, a little over a year and a half ago. You also see it again in Mr. Yap's 5th affidavit at page 2583. That's at paragraph 28. Investigations into Francis Troy and Broad Idea are ongoing, but it's anticipated that substantive proceedings will be commenced against both very shortly. This is not a procedural defect that can be waived. This is a substantive issue that goes to the core of the jurisdiction of the court to grant an injunction. CCL has recognised that and has repeatedly said that it's just about to do something to make some substantive allegations, but it never has. It has no case, it cannot articulate a case, it cannot plead a case, there is no case against Broad Idea. As a result, not only is there no possibility of a trial, CCL has never had to articulate in a single document what its case might be, how it is to be made out, and by reference to what primary facts. Returning to page 915, if I may, the appearances are only on behalf of CCL and Broad Idea. Then the recital identified at the bottom of the page identifies the only notice of application upon which CCL sought to rely. That's a notice of application as required by Rule 11.7.1, and that's Rule 11.7.1 requires a notice of application to state briefly the grounds on which the applicant is seeking the order. For your Lordship's note, the relevant rule is at page 13.585. The notice of application itself is found from page 26. The grounds appear on the next page from page 27. As you can see from page 27 down to page 29, nothing is said about why Broad Idea's assets are to be regarded as those of Dr. Cho, or how or why they should be available for execution. Were the board to have the time or the inclination, that absence of any articulated case is not cured by reading Mr. Yap's affirmations, line by line, as occurred before the Court of Appeal. Returning to the terms of the order itself, at page 916, halfway down the page, paragraph 2 records that the order is made until further order. Where there is to be a trial on the merits, the form of the order would be until trial or further order. But the terms of this order never require there to be a further hearing. It is in effect a final injunction. Paragraph 2A1 records the fact that Broad Idea is restrained from dealing with its own assets up to a stated value. There are three aspects to this subparagraph. First, it is an injunction directly against Broad Idea's own assets. This goes beyond what the Hong Kong Court of Appeal has ordered. Secondly, it is a value that is set independently of any consideration of any assets owned by Dr. Cho, who does not feature at all. It thus freezes Broad Ideas assets independently of the value of Dr. Cho's indirect economic interest represented by his shareholding. And in this case, Broad Ideas assets are principally its shareholding, 100% its shareholding in Town Health International. And the value injuncted represents significantly more than 50.1% of the net value of those assets. Thirdly, as far as this court is concerned, recovery from Dr. Cho is irrelevant, as the figure is not net of his assets. The injunction is not supportive of the Hong Kong position at all. It's entirely independent. Over the page at page 917, paragraphs 2A2 to 6 record prohibitions on Broad Idea from causing, permitting, allowing or recording any changes to its share structure, even if those shares have nothing to do with Dr. Cho. And you see that at the end of sub-paragraph 2, it's and held by Cho Kwai Chee, also known as Roy Cho, and any other person. It's effectively restraining the recording of any transaction in relation to anybody holding shares in Broad Idea. Again, this goes beyond what has been ordered by the Hong Kong Court of Appeal. Further, it's impossible to understand any basis that might exist for obtaining an order against or in respect of assets that cannot possibly be subject to satisfaction of any judgment in Hong Kong Action 399 of 2018 against Dr. Cho. There is no evidence anywhere in the record relating to the merits or value of any claims in any other actions or against any other persons or entities. And one asks rhetorically, why should someone be restrained from recording accurately in their books and records the proper detail of specific third-party transactions? That's not a freezing order. It does not restrain the transaction itself. It simply prevents the proper acknowledgement of the fact of that transaction, and it does not alter the legal reality of what occurred. No argument was advanced by CCL, and why should it extend in particular to Mr. Choi's shares? Then over the page again, page 918, paragraph 3A is the identification of the specific assets that CCL wants to attach, namely Broad Ideas shares in Town Health International Medical Group Limited, shares that Broad Idea has held since 2005, before CCL was even incorporated. Then paragraph 4B, CCL is recorded as records being determined by the court a right to notify this order outside the jurisdiction. And then it records the identity of those officers being precisely the people who are in Hong Kong and subject to the jurisdiction of that court, rather than this. So it's getting an order in the BVI to injunct directors, notifying them in Hong Kong. The Hong Kong court is seized of these proceedings. It's a matter properly for the Hong Kong court. So the terms of this order go beyond that which the Hong Kong Court of Appeal was asked to grant. This order looks directly into the assets of Broad Idea and also purports to restrain the ability of all other shareholders in Broad Idea to effect any transactions in relation to their shareholdings, despite the fact that no relief is sought against them in 399 of 2018. The grounds relied upon in support of the relief claimed in the notice of application articulate no intelligible basis for the order obtained. And CCL has failed to conform to the most basic procedural requirements of the CPR to issue and serve a claim in a claim form identifying the right or rights asserted to support its interim relief. despite having represented to the court repeatedly that it was just about to do so. Accordingly, the order obtained is neither in support of nor in relation to Hong Kong proceedings to which Broad Idea is not a party, nor can it have any freestanding life of its own in the absence of any such substantive proceedings. The second point I'd like to address in my oral submissions is that Broad Idea, as a legal person, is entitled to the free use and enjoyment of its property unless there's some lawful basis identified by CCL upon which Broad Idea can be deprived of such. And CCL has wholly failed to do so. Now, the starting point for the development of this argument is the fundamental proposition that people, both natural and legal, are entitled to the free use and enjoyment of their own property and will not be deprived of such, save in accordance with the law, as guaranteed by the Constitution of the Virgin Islands in accordance with the Virgin Islands Constitution Order, and you'll find that section 9C at page 14146, which recognises a fundamental right and freedom from deprivation of property save in the public interest, and that's spelt out in greater detail in section 25 at page 14154. I hesitate to say this, but it's a sentiment that's run through English law since Magna Carta. It's therefore not open to the court to deprive anyone, even a company, of the use of their property except in accordance with the law, which by implication cannot occur unless a claimant before the court is asserting a legal or equitable claim to that property. That analysis is not affected simply because Broad Idea is a company and Dr. Cho is one of its shareholders. Now, CCL makes no attack on the line of cases from Salomon and Salomon down to Preston Prest, nor could it properly do so. It is a fundamental principle of company law that a company, its assets and liabilities are legally distinct and separate from those of its shareholder. If I may, in order to set the parameters clearly, might I invite your lordships to turn up Preston Prest and go directly to paragraph 8 of Lord Sumption's speech at page 12343. And he says this: subject to very limited exceptions, most of which are statutory, a company is a legal entity distinct from its shareholders. It has rights and liabilities of its own, which are distinct from those of its shareholders. Its property is its own, and not that of its shareholders. In Salomon and Salomon, the House of Lords held that these principles applied as much to a company that was wholly owned and controlled by one man as to any other company. In Macara and Northern Assurance Company Limited, the House of Lords held that the sole owner and controller of a company did not even have an insurable interest in property of the company, although economically he was liable to suffer by its destruction. Lord Buckmaster said, no shareholder has any right to any item of property owned by the company, for he has no legal or equitable interest therein. He's entitled to a share in the profits while the company continues to carry on business, and a share in the distribution of the surplus assets when the company is wound up. In Lonhro and Shell, the House of Lords held that documents of a subsidiary were not in the power of its parent company for the purposes of disclosure in litigation simply by virtue of the latter's ownership and control of the group. These principles are the starting point for the elaborate restrictions imposed by English law on a wide range of transactions, which have the direct or indirect effect of distributing capital to shareholders. The separate personality and property of a company is sometimes described as a fiction, and in a sense it is. But the fiction is the whole foundation of English company and insolvency law. As Lord Justice Robert Gough once observed, in this domain we're concerned not with economics but with law. The distinction between the two is, in law, fundamental. He could justly have added that it is not just legally but economically fundamental, since limited companies have been the principal unit of commercial life for more than a century. Their separate personality and property are the basis on which third parties are entitled to deal with them and commonly do deal with them. Lord Sumption then identified two circumstances in which the assets of a company might be available to satisfy claims from a third party. The first is when the corporate veil can be pierced, and one can see this from paragraph 27 on page 12351, with his conclusion at paragraph 35 on page 12355. He says this: I conclude that there is a limited principle of English law which applies when a person is under an existing legal obligation or liability, or subject to an existing legal restriction which he deliberately invades or whose enforcement he deliberately frustrates by interposing a company under his control. The court may then pierce the corporate veil for the purpose, and only for the purpose, of depriving the company or its controller of the advantage that they would otherwise have obtained by the company's separate legal personality. That is not the situation that pertains here. Broad Idea has been a holding company with the same shareholders and the same shareholding in Town Health since 2005. It has not been interposed in any sense. The second occasion, identified by law assumption, is when the beneficial ownership of an asset is not that of the company itself, but is instead that of its shareholder or someone else. And you see that from paragraph 43 of his speech at page 12,358. Now, the basis for an attack on Broad Idea's assets was rejected by the Court of Appeal at page 995 in paragraph 57, and at paragraph 61 on page 997, and at 63 to 67 at page 998. So the case as advanced below was simply not made out on the evidence. There was no basis for looking into Broad Idea's assets and saying they belonged to Dr. Cho. This line of reasoning, a right of a person to use their own property unless there is a claim in relation to it, and the circumstances in which a freezing order over the assets of a third party may be granted, resonates with the reasoning of the High Court of Australia in a case that I'm reliably informed by my learned Australian junior, Mr. MacLeod, is called Cardilli and LED Builders. And that appears from page 9865. And if I may, subject to your lordships, I'd like to spend a little bit of time looking at this case. It's been adopted in the Cayman Islands in a case called Al-Basabi and Saad. It's received judicial approval in England and Wales, not least by my Lord Briggs in his case, HMRC and Eggleton, and in a number of other cases, for the for the end result, for the test to be applied in order to obtain an injunction against the assets of third parties. But the analysis, the reasoning of the High Court of Australia, although on different wording and adopting perhaps a different approach to the reasoning for the grant of freezing orders, nevertheless bears some consideration, not least because it illustrates why, if one's going down the protection of the court process route, there needs to be a claim to which the respondent is a party, and where there is going to be an entitlement to look to the assets of the third party to satisfy the eventual judgment. You can't, put crudely, you can't interfere with the process of the court if you actually are not engaged with the process of the court. So if I may, could I start at page 9865? And you'll see, first of all, as my learned friend Mr. McGrath correctly said, Section 23 of the Federal Court of Australia Act is in different terms. The restrictions on the High Court of Australia are in terms that the court has power in relation to matters in which it has jurisdiction to make orders. So you're not looking at a case in which it's just or convenient. Then over the page, at page 9866, one sees the facts. So this is a claim by LED Builders against Eagle Homes Property Limited for infringement of copyright. The shares in Eagle Homes were owned by Mr. and Mrs. Cardilli, and they caused Eagle Homes to pay certain dividends to themselves. Another company called Ultramodern was incorporated in 1995. It was controlled by the Cardillis, and they began to use it to construct other houses using the business name Eagle Homes. And then Eagle Homes paid further dividends. There was judgment in the infringement proceedings given in favour of LED in 1996. LED elected for an account of profits and sought moravian orders against Eagle Homes, the Cardilli, and sought moravian orders against Eagle Homes, the Cardillis, and Ultramodern. And then, if I may, I'd like to go straight into the body of the text of the judgment of the majority at page 9876, at paragraph 17. The appellant's principal contentions are that they have not been shown to have been, or prospectively to be, a recipient of any property of Eagle Homes. Even assuming a power to make an order against the corporate appellant, that order must be confined in operation to assets of Eagle Homes in the hands of Ultramodern and subject to execution. So this is a proprietary part of the claim. And then over the page, paragraph 18, subject to the view that we should take in relation to the business name Eagle Homes and the dividends paid to the personal appellants, we would accept what the appellants put in relation to the factual situation, that the appellants have not, and with one exception, been shown to have come into possession of any of Eagle Homes' property, and there is no evidence that they're about to do so. The heart of the reasoning of Justices Beaumont and Branson is to be found in part of the judgment that we have already quoted, where their honours held it was not open to Mr. Justice Emmett to conclude, if he did so conclude, that there was no risk that assets will be disposed of by Ultramodern at the direction of Mr. and Mrs. Cardilli, with a view to abusing or frustrating the court's process. Paragraph 20. Ultramodern is entitled to dispose of assets that it owns or has lawfully acquired. To dispose of its own assets without more and with no substantive proceedings have been taken against it cannot be said to be an abuse or frustration of the court's process in respect of litigation between other parties. Then at the bottom of the page, paragraph 24, Ultramodern has not been shown to own or hold or have the power of disposition over any property of Eagle Homes, nor in any way at all to owe any obligations or debts to that company, save perhaps the business name Eagle Homes, which we set aside for separate consideration. Now, the learned justices then move on at page 9880 to set out in paragraph 31 how they understand the law in England to be. However, in England, it's now settled by several decisions of the House of Lords that the power stated in judicial legislation that the court may grant an injunction in all cases in which it appears to the court to be just and convenient to do so, does not confer an unlimited power to grant injunctive relief. Regard must still be had to the existence of a legal or equitable right which the injunction protects against invasion or threatened invasion or other unconscientious conduct or exercise of legal or equitable rights. The situation thus confirmed by these authorities reflects the point made by Ashburner that the power of the court to grant an injunction is limited by the nature of the act which it is sought to restrain. And then at paragraph 41 on page 9884. The body of the reasoning starts, paragraph 41, page 9884. In Australia, this is the doctrinal basis of the Moreover order. In Australia, that view of the matter, and that view of the matter is that the power is that of the court to protect its own process. That view of the matter has been urged for many years. It is seen in the most recent statement of principle in this court concerning the jurisdiction of the federal court to grant a Moreover order. In Patrick Stevedore's Operations Number 2 Proprietary Limited and Maritime Union, in their joint judgment, the Chief Justice and the other justices said this: interlocutory relief. Powers of the federal court under section 23 of its act are powers to make orders of such kinds, including interlocutory orders, as it thinks appropriate, as Justice Dean noted in Jackson and Sterling Industries. He added, wide though that power is, it is subject to both jurisdictional and other limits. It exists only in relation to matters, and that's picking up the wording of the section, in respect of which jurisdiction has been conferred upon the federal court. Even in relation to such matters, the power is restricted to the making of the kinds of order, whether final or interlocutory, which are capable of properly being seen as appropriate to be made by the federal court in the exercise of its jurisdiction. One limit of the powers of the federal court to grant interlocutory injunctions is that those powers must be exercised for the purpose for which they are conferred. In a later passage of the judgment of Justice Dean and Jackson and Sterling Industries, His Honour said a power to prevent the abuse or frustration of a court's process should be accepted as an established part of the armoury of a court of law and equity, and that the power to grant such relief in relation to a matter in which the federal court has jurisdiction is comprehended by the express grant to that court by section 23. But His Honour observed, orders must be framed so as to come within the limits set by the purpose which the order can properly be intended to serve. The Moreover injunction is a paradigm example of an order to prevent the frustration of a court's process, but other examples may be found. The moulding of an interlocutory injunction must depend upon the circumstances of each case. As Justice Brennan observed in Jackson, a judicial power to make an interlocutory order in the nature of a Moreover injunction may be exercised according to the exigencies of the case and the schemes which a debtor may devise by divesting himself of assets being legion. Novelty of form is no objection to the validity of such an order. The general principle which informs the exercise of the power to grant interlocutory relief is that the court may make such orders, at least against the parties to the proceeding against whom final relief may be granted, as are needed to ensure the effective exercise of the jurisdiction invoked. The federal court had jurisdiction to make interlocutory orders to prevent frustration of its process in the present proceeding. Subject to two matters to which we shall come, this passage should be accepted as a correct statement of principle. The first matter is that in that passage, the attention of the court was directed to orders against parties to proceedings and against whom final relief was sought. In that situation, the focus is the frustration of the court's process. If relief is available against non-parties, the focus must be the administration of justice. The second matter is that to avoid confusion as to the doctrinal basis, it's preferable that references to Moreover orders be substituted for injunctions. Then skipping down to paragraph 44, here Ultramodern and Mr. and Mrs. Cardilli are third parties in respect of LED's actions against Eagle Homes. The effective exercise of the jurisdiction in such litigation may call for asset preservation orders against third parties who may hold or otherwise be interested in the sense we explain further in these reasons, assets of the judgment debtor or potential judgment debtor, or who may be obliged to contribute to the property of such a judgment debtor to help satisfy the judgment. And then third parties. In this litigation, as been mentioned, final judgment on LED's claim against Eagle Homes for a money sum is still pending. The appellants correctly submit that the statement of principle in Patrick Stevedore's provides no basis for making an order against a non-party, such as Ultramodern, which is not answerable or liable in some way to a party, plaintiff or defendant, in a proceeding where judgment has not been obtained or execution recovered, or not holding, controlling, or capable of disposing of the property of a party in that proceeding. This proposition, negative in character, should be accepted. So, just pausing there, broad idea is ultra-modern. There is nothing that will arise from the Hong Kong judgment that will give CCL any entitlement to broad ideas assets. Then over the page, at page 9887, paragraph 48, LED's stance in this appeal is that it is not essential that the court's process in support of which the moravian relief is sought be confined to those set in motion upon a cause of action. That followed, it is submitted, from a passage in the speech of Lord Mustill in Channel Tunnel, to which Lord Justice Hoffman referred in Mercantile Group and Ayala. That Mercantile Group and Ayala was a case in which Mrs. Ayala was already joined as a co-defendant within the proceedings. You see that at page 14880, if you wish to look at it in due course. In holding that the wife of the judgment debtor should be restrained from disposing of assets, although no action had been brought against her. Lord Mustill said that the right to an interlocutory injunction, which is incidental to and dependent on the enforcement of a substantive right, usually, although not invariably, takes the shape of a cause of action. However, we do not think that his lordship was suggesting that an order might be made against a non-party, not amenable in some way ultimately to some coercive process requiring it to disgorge, or in some other way to participate in the satisfaction of a judgment against a party. LED argues that its substantive rights are the final injunctive orders already made by Justice Davis against Eagle Homes, following the determination of the issue of liability upon LED's actions for copyright infringement. Even if this be accepted for present purposes, LED still has the problem, which in our opinion the evidence does not resolve in its favour, of showing that recourse may be had to the appellants to satisfy LED's prospective money judgment against Eagle Homes. As LED submits, the development of this ancillary jurisdiction to grant moravian orders has been an evolving process, and the courts have approached the different factual situations as they have arisen, flexibly. There is a temptation to use the term flexible to cloak a lack of analytical rigour and to escape the need to find a doctrinal and principled basis for orders that are made. There are significant differences between an order protective of the court's process, set in train against a party to an action, including the efficacy of execution available to a judgment creditor, and an order extending to the property of persons who are not parties and who cannot be shown to have frustrated, actually or potentially, the administration of justice. It's been truly said that a moravian order does not deprive the party subject to its restraint either of title to or possession of the assets to which the order extends, nor does the order improve the position of a claimant in an insolvency of the judgment debtor. It operates in personam and not as an attachment. Nevertheless, those statements should not obscure the reality that the granting of a moravian order is bound to have a significant impact on the property of the person against whom it is made. In a practical sense, it operates as a very tight negative pledge, species of security over property, to which the contempt sanction is attached. It requires a high degree of caution on the part of a court invited to make an order of that kind. An order lightly or wrongly granted may have a capacity to impair or restrict commerce just as much as one appropriately granted may facilitate and ensure its due conduct. If I might invite your lordships then to turn on to page 9890, where the majority draw together what they take to be the test. Paragraph 57, and this is the passage previously endorsed by my Lord Briggs and adopted in Al-Ghasabi. What then is the principle to guide the courts in determining whether to grant moravian relief in a case such as the present, where the activities of a third party are the objects sought to be restrained? In our opinion, such an order may, and we emphasise the word may, be appropriate, assuming the existence of other relevant criteria and discretionary factors, in circumstances in which the third party holds, is using, or has exercised, or is exercising a power of disposition over, or is otherwise in possession of assets, including claims and expectancies, of the judgment debtor or potential judgment debtor. And pausing there, And to summarise that crudely, that's the nominee, trustee or agent type position. Or 2, some process ultimately enforceable by the courts is or may be available to the judgment creditor as a consequence of a judgment against the actual or potential judgment debtor, pursuant to which, whether by the appointment of a liquidated trustee and bankruptcy receiver or otherwise, the third party may be obliged to disgorge property or otherwise contribute to the funds or property of the judgment debtor to help satisfy the judgment against the judgment debtor. And that's the extended limb to the test. Now, if the purpose of a freezing order is to protect the process of the court, it illustrates the need for the third party to be engaged as a party with that process of the court. The need for there to be a substantive claim before the court against the principal defendant is the corollary of that, and the need for there to be material to satisfy the court that there is a good arguable case that the assets of the third party will be available for satisfaction of any judgment against the principal defendant is the necessary evidential threshold. These points are illustrated in the judgment of the Cayman Court of Appeal in Al-Ghasabi and Saad. That's found starts at page 9521, but if I might like to take your lordships to page 9526. And at paragraph 10, you see there, in that context, the judge's reference to a non-cause of action party is to a party who is named as a defendant to the proceedings, but against whom no cause of action is alleged in the pleading claim. And then he goes on to identify who the NCADs are. That's the same position as pertained in TSB and Chabra, where the company was joined as a party to the proceedings when the freezing order was granted against it. And you see that in page 13030, and Mercantile Group and Ayala, page 14892, where Mrs. Ayala was already a party. Then after approving the Cardilli test at paragraph 26 of the judgment at page 9531, the President went on, paragraph 42 on page 9537, to articulate both the limits of the relief and the practical test for the relief. It's from paragraph 42. He identified a hard limit to the breadth of the injunction, namely the claimant cannot achieve through the injunction better recourse to assets than actually are possessed by the defendant. Put slightly differently, the injunction cannot vest the claimant with rights or a better position than that possessed by the defendant. In the present case, even were an injunction against broad idea justifiable, there can be no possible justification to injunct more than Dr. Cho's pro rata financial interest in broad idea, represented by the value of his shareholding in it. Nor is there any justification for impeding the dealing of other shareholders freely with their shares. The order of Justice Adderley, and that granted by the board on CCL's application for an injunction pending the hearing of this appeal, must be wrong in principle to the extent that they injunct broad ideas assets directly and impact upon the interests of shareholders other than Dr. Cho. Going back to Al-Ghasabi, at page 9539, at the end of paragraph 46, President points out that substantive control is not enough to justify an injunction over the assets of a third party. He then goes on in paragraphs 47 and 49 to make a point about procedural fairness, namely that the possible claim against the third party must be clearly formulated with a degree of specificity appropriate to the evidence before the court. On the matter the subject of this appeal, not only is there no clear formulation and no specificity in the notice of application or the evidence in support, there's also no evidence at all that could support a properly formulated application for the relief to which CCL claims it's entitled, a matter to which I shall return in point 4 of my oral submissions. However, the consequence of this deficiency and the failure of CCL ever to plead a claim in a claim form is that CCL's case is a mirage that changes on each occasion that it comes before the court. So on the ex parte application, CCL makes almost no reference to broad idea, and its evidence does not address any claim to be entitled to access to broad ideas assets. Mr. Yap's first affirmation fails to address the point. It follows the approach taken by Justice Bannister in Black Swan, in simply asserting that Dr. Cho is a shareholder in broad idea and relying on that simple fact to justify freezing broad ideas assets. And if in due course your lordships are minded to review Mr. Yap's first affirmation and indeed the skeleton argument and indeed the transcript of the hearing before Justice Chivers, then you will find no more enlightenment as to the basis for the claim against broad ideas assets than I've just given you. Before Justice Adderley, CCL made generalised assertions against Mr. Choi that were not made out in the evidence, and generalised claims that broad idea was Dr. Cho's money box or a mere nominee without reference to any evidence. And you see that rejected by the Court of Appeal in its judgment, saying that Justice Adderley simply stated that it was a money box case and didn't identify any evidence or any reasoning for that conclusion, and indeed there was none. Before the Court of Appeal, CCL asserted that broad ideas assets would be available to satisfy a judgment obtained against Dr. Cho, without really explaining how or why, but seemingly on the basis that broad idea was a mere nominee for Dr. Cho, but again without any supportive evidence, nor any evidence supporting why it should go beyond Dr. Cho's economic interest. Immediately after broad ideas appeal was allowed, in support of a stop notice over both Dr. Cho and Mr. Choi's shares in broad idea, CCL asserted for the first time that it had a beneficial interest in broad ideas shares. And you find that asserted in paragraph 16 on page 7304. Quite how CCL, which was incorporated after 2012, could have a beneficial interest in broad idea, whose shares have been the same since 2005, is not explained. Before this board, CCL runs a range of factual allegations in its written case, but that case is flawed at two levels. First, it fails to explain how its allegations actually satisfy any, and if so, which part of any test that might entitle it to an injunction against broad ideas assets or its other shareholder, and the simple fact is that they don't. Secondly, those allegations are at best misleading and at worst positively untrue. By way of just one example, identified at paragraph 13 in Appendix 1 to Broad Ideas written case at 9314, by reference to paragraph 215.9 of CCL's written case, and that's perhaps this is worth looking at, page 9228. So this is subparagraph 9 on page 9228. Your lordships, and there are many examples, but this is, and I may come back to some, but subparagraph 9 on page 9228, Broad Idea and Town Health are identified as companies within the Enigma network. This is trying to just make it look as if Broad Idea is somehow involved in misconduct. And the Enigma network, which has no relevance to 399 of 2018, is prey to of all sorts of allegations. But if your lordships be kind enough to click on the hyperlink, takes you to page 898, 899, and 900. You will not find Broad Idea on those pages. The same is true of a number of the other hyperlinks, but what is said in CCL's written case on occasion is simply false, demonstrably false on any rational basis, or built on its own previous statements in previous skeleton arguments. When the Court of Appeal said there was no evidence, it did so after a careful, line-by-line, painstaking analysis of all the evidence properly so called, and it reached the judgment that it did after CCL having had every opportunity to identify any single piece of evidence that was being overlooked. My Lords, I notice that it's just past 4 o'clock. Might that be a convenient moment?
Yes, certainly. Thank you, Mr. Morgan. We'll adjourn then and sit again at 10:30 tomorrow morning.
I'm grateful.
Thank you very much.